I want to talk about the Epstein case, the investigation surrounding it, the limitations in what the public actually knows, and the broader constitutional questions that it inevitably leads to. The Epstein files have become one of the most discussed sets of documents in modern legal history because they involve serious allegations, sealed records, and a long-standing debate about transparency. When people ask whether Epstein trafficked individuals to others besides himself, the answer must be based strictly on what is established in public records. The 2019 federal indictment focused on sex trafficking offenses involving minors, but the government did not charge anyone else as a recipient of victims. Officials who worked on earlier stages of the case have said that the scope of evidence was significantly limited by the non-prosecution agreement that Epstein received in 2008. That agreement restricted federal investigative action and sealed certain materials, which is why so many questions remain unanswered. The public often assumes that the files contain explosive secrets, but legally, prosecutors can only acknowledge what is verified and admissible. That is why the record states that Epstein primarily trafficked victims to himself, and additional names were not charged based on available evidence. This lack of clarity frustrates many people because it appears that a powerful individual received legal protection that would not be available to ordinary citizens. The case highlights how influence, wealth, and negotiated agreements can alter the trajectory of an investigation. It also exposes the tension between public demand for answers and the constraints placed on investigators by previous legal decisions. Many experts believe that only full transparency, through lawful document releases, can resolve public suspicion. Others argue that some files involve sensitive information that must remain sealed to protect victims. This balance between transparency and privacy is at the center of the ongoing debate. But the larger, more urgent issue raised by these discussions is the question of presidential power, accountability, and the limits of the pardon authority. The Constitution gives the president broad power to grant pardons for federal crimes. However, nowhere in American history has a president issued a self-pardon. This is not just a legal curiosity. It is a potentially system-defining question that tests the strength of the Constitution. Most constitutional scholars believe that a president cannot legally pardon himself because doing so would break the principle that no person may be a judge in their own case. The American justice system is built on the idea that laws apply equally to everyone, including the president. A self-pardon would invert that idea by allowing a president to grant himself immunity from federal prosecution, effectively placing himself above the law. Legal historians often point out that the founders specifically designed checks and balances to prevent the rise of an unaccountable executive. The pardon power exists to show mercy, correct judicial mistakes, and ensure justice when courts fail. It was never intended as a tool for personal protection. If a president could erase his own criminal liability, he could engage in bribery, obstruction, tax violations, or other federal offenses without consequence. That would fundamentally contradict the structure of a constitutional republic. Furthermore, presidential pardons do not extend to state-level charges. This means that even if a self-pardon were attempted, it would have no effect on state prosecutions, state courts, or state civil findings. This distinction reflects the dual sovereignty system in the United States and is a core reason why legal experts doubt the viability of a self-pardon. Any president attempting such a pardon would immediately trigger a historic constitutional confrontation. Congress would likely view the attempt as an abuse of power and could initiate impeachment proceedings on the grounds that the president was obstructing justice. The courts would likely be forced to rule on the constitutionality of the action. And the public reaction would be intense because the idea of a leader attempting to shield himself from the law violates widely held moral and democratic expectations. People understand instinctively that unrestricted executive power is dangerous. History has repeatedly shown that democracies collapse when leaders decide they are immune from accountability. That is why scholars say the question of self-pardons is not simply a legal debate, but a test of the nation's values. This discussion is especially important in periods of political division or when investigations into powerful figures are underway. It is during these times that citizens must understand how the Constitution restrains power. The separation of powers, judicial oversight, congressional authority, and public scrutiny all work together to prevent abuses. If a self-pardon were attempted, It would activate every mechanism designed to protect the republic from authoritarian behavior. Courts could strike it down. Congress could impeach. State prosecutors could still file charges, and the public could demand action. No single institution is designed to handle such a crisis alone, but together, they create a system capable of responding to unprecedented challenges. The Epstein case and the debate over presidential pardon limits share a common theme. They both expose how individuals with power can test the boundaries of legal systems. They both reveal how important transparency, oversight, and accountability are to maintaining public trust, and they both demonstrate that the rule of law must apply equally to everyone if a democracy is to survive. These issues are not abstract principles. They shape how the public views justice, fairness, and institutional legitimacy. They influence how future leaders will behave. And they remind citizens that the health of a democracy depends not only on elections, but on the ongoing enforcement of legal and ethical standards. As more information becomes available through legal proceedings, document releases, or court rulings, the public will continue to revisit these topics. It is essential to approach them with clarity, caution, and a commitment to facts. The United States has faced constitutional crises before, and each one has tested the strength of its institutions. The debates surrounding Epstein's records, presidential pardon powers, and the limits of executive authority are part of that ongoing process. Understanding them is not only important for political awareness, but vital for preserving democratic norms and ensuring that power remains accountable to the law. To fully understand why debates around self-pardons, high-profile investigations, and the boundaries of presidential authority matter so deeply, we need to examine the underlying architecture of the American legal system. The United States was built on a deliberate design that divides power so no single individual can dominate the government. The founders had just escaped a monarchy. They understood what happens when one leader can control the courts, manipulate the law, and evade accountability. This is why the Constitution separates authority into three co-equal branches, each with its own tools for stopping unlawful or abusive behavior from the others. The presidency was intentionally made both powerful and limited. Presidents command the military, influence policy, lead the nation, and execute federal law. But they are also bound by the Constitution, subject to congressional oversight, and answerable to the courts. One of the greatest misunderstandings in modern politics is the belief that executive power is absolute. In reality, the presidency is one of the most constrained offices in democratic governance. A president cannot unilaterally rewrite laws, cancel investigations, or declare immunity. Each branch of government acts as a counterweight because the founders expected future leaders to face temptations, political pressure, and the potential for misconduct. Checks and balances are not theoretical ideas. They are practical safeguards against the darker possibilities of human nature. This is why legal scholars consistently warn that any attempt by a president to place himself above the law would destabilize the constitutional framework. A self-pardon is not just a legal maneuver. It challenges the very logic of accountability that keeps democratic institutions functioning. If a leader could erase their own criminal liability, the deterrent effect of the law would vanish. The presidency could become a shield for personal interests rather than a role of public service. Legal experts often point to the principle established in the 1803 Marbury v. Madison decision. The United States is a government of laws, not of individuals. This case cemented the idea that the judiciary has the final say in interpreting the Constitution. If a president attempted a self-pardon, the courts would have the authority to determine whether such an action aligns with constitutional principles. It is also important to remember that historical cases exist where individuals in power attempted to stretch or manipulate the limits of their authority. Throughout American history, political figures have tested boundaries during times of crisis. Some have abused power, while others have acted boldly to protect national security. In each instance, the country had to balance strong leadership with constitutional restraint. The Watergate scandal is one example. The Iran-Contra affair is another. These moments are reminders that even in a stable democracy, power can drift toward overreach if institutions are not vigilant. The system survives only when all branches respond firmly to actions that threaten constitutional order. Public opinion also plays a major role in preserving the rule of law. Citizens care deeply about fairness, integrity, and transparency. When they feel the justice system favors powerful individuals, trust erodes quickly. This is why large, controversial cases, whether involving political leaders, financial elites, or influential figures, often produce intense public reactions. People want assurance that the law applies to everyone equally. They want to believe that institutions still function, that investigations are real, and that accountability is possible. When public trust weakens, polarization increases, conspiracy theories spread, and institutions face even more pressure to prove their legitimacy. This tension is evident in discussions about the Epstein case. The combination of sealed records, plea deals, and unanswered questions created a vacuum of trust that still affects the public today. The same dynamic emerges in debates about presidential powers. These situations reveal that the health of a democracy depends not only on written laws but also on public belief that those laws are enforced fairly. Transparency, documentation, and independent oversight are essential because they prevent speculation from filling the gaps when official information is limited. A government that operates behind closed doors invites suspicion. A government that provides clear and consistent information strengthens stability. Another critical factor is the role of state and federal jurisdictions. Many people assume that a presidential pardon can wipe away all legal problems. That is not true. Presidential pardons apply only to federal crimes. State-level investigations, state lawsuits, and state criminal charges exist entirely outside presidential authority. This separation ensures that power is decentralized. It allows state courts to act independently if federal institutions are compromised or constrained. Legal scholars often praise this division as one of the strongest safeguards against authoritarian behavior. Even in a scenario where federal processes are disrupted, state-level checks remain intact. Furthermore, an attempted self-pardon would not stop Congress from conducting oversight or impeachment. The Constitution explicitly states that pardons cannot interfere with impeachment. That means even if a president attempted a self-pardon for federal crimes, he could still be impeached and removed based on abuse of power, corruption, or obstruction. The impeachment process exists precisely for situations where a president tries to misuse authority in ways that threaten democratic stability. This is why legal experts argue that no president can use the pardon power as a personal escape mechanism. The Constitution anticipates the possibility of misconduct and provides structural tools to address it. When discussing these subjects, it becomes clear that the American system was built with remarkable foresight. The founders could not predict every future crisis, but they understood that power must always be challenged, questioned, and restrained. They knew that no office, not even the presidency, could be trusted without oversight from the others. This philosophy is what allows the United States to confront crises without abandoning its democratic foundations. It is also why debates about self-pardons, sealed investigations, or high-profile legal cases become so intense. They strike at the heart of what defines the country's identity and values. Whether the discussion centers on high-profile criminal investigations or controversial political decisions, the underlying message is the same. Accountability is not optional. It is a requirement for any functioning democracy. Presidents, judges, wealthy individuals, and public officials all operate under the law. The moment any individual becomes untouchable, the entire system risks losing legitimacy. For this reason, it is crucial for the public to stay informed, for the media to report responsibly, and for institutions to act transparently. These principles protect the country from internal decay and reinforce the idea that democracy is sustained through vigilance, courage, and adherence to the rule of law. To complete this discussion, it is important to understand how all of these issues, presidential authority, constitutional limits, high-profile investigations, and public trust, intertwine to shape the stability of democratic systems. Democracies depend not only on written laws, but also on a culture of accountability and the willingness of institutions to enforce limits on power. When structural safeguards are tested, the strength of the system becomes visible. How institutions respond during moments of pressure reveals whether a nation's principles are merely symbolic or genuinely operational. One of the most significant challenges that arises in any democracy is the gap between public expectations and legal reality. People want clear answers, swift justice, and transparent processes, especially during high-profile cases. But the legal system often moves slowly, deliberately, and with constraints that can frustrate the public. This tension becomes more pronounced when influential individuals are involved, because the public naturally expects that power should not grant immunity. When investigations involve sealed documents, confidential agreements, or sensitive testimony, people feel that fairness is being compromised, even when legal procedures are being followed. The Epstein case became a symbol of this conflict, raising questions that many believe remain unresolved. It serves as a reminder that public trust is fragile, and that transparency is not only a legal responsibility, but also a moral one. This brings us back to the conversation about presidential accountability. Leaders operating in a system of checks and balances must always recognize that authority is conditional. Presidents hold extraordinary power, but they do not own the office. They are custodians of temporary authority designed to serve the public, not themselves. Attempts to stretch constitutional limits, whether through aggressive executive actions or hypothetical attempts at self-pardons, fundamentally threaten the principle that leadership comes with responsibility, not immunity. The strength of a democracy rests on the certainty that no officeholder is exempt from the law. If a leader could legally insulate themselves from consequences, the balance of power would collapse, and the executive branch would overshadow all others. The possibility of a self-pardon therefore represents more than a legal question. It reflects a psychological and philosophical struggle at the heart of governance. Power naturally tempts individuals to protect themselves, especially in moments of vulnerability or political turmoil. But the Constitution intentionally restricts the presidency to prevent this instinct from becoming policy. It is a system designed to resist the pressures of ambition, self-interest, and political survival. Constitutional scholars frequently emphasize that the United States must operate on rules rather than personalities. If the rules bend to accommodate the needs of individuals, the institutions themselves weaken, setting dangerous precedents that future leaders may exploit. Public vigilance plays an essential role in preventing such erosion. Citizens must be informed, engaged, and willing to question authority. Governments remain accountable only when the public expects transparency and consistency. When people stop demanding answers, institutions become complacent. When people stop caring about the rule of law, abuses multiply. Societies that lose faith in their legal systems inevitably become unstable. That is why public awareness, education, and civic participation are not optional components of a democracy. They are pillars that maintain the integrity of the system. Every major constitutional test, from Watergate to modern investigations, has shown that public pressure influences the behavior of institutions. When the public stays alert, the justice system is more likely to act responsibly. Another important aspect to consider is the role of history. Democracies learn from their crises. Each major test reveals weaknesses in the system that can later be corrected through reforms. After Watergate, new oversight laws were created. After intelligence scandals, new committees were formed. After financial crises, new regulations were implemented. Similarly, debates about presidential immunity and self-pardons may lead to future reforms that clarify constitutional boundaries. Scholars have already proposed amendments or legislation that would explicitly prohibit self-pardons, standardize investigative transparency, or strengthen protections against executive overreach. These conversations are part of the continuous process of refining democracy. Ultimately, the enduring lesson from all these topics, high-profile investigations, sealed records, constitutional debates, and questions of presidential accountability, is that democracies survive only when they prioritize the rule of law above personal loyalty, political pressure, or institutional convenience. The Constitution was written not to prevent problems, but to manage them. It anticipates conflicts, disagreements, and abuses, and it provides frameworks for resolving them without destroying the nation's foundation. The law is not perfect, and neither are institutions, but their strength lies in their ability to adapt, respond, and improve when challenged. As this discussion concludes, it becomes clear that the future stability of any nation depends on maintaining a balance between power and accountability. Transparency must be protected. Institutions must remain independent. Public officials must respect legal boundaries. Citizens must stay informed and engaged. And the justice system must treat all individuals, wealthy or ordinary, powerful or private, according to the same standards. These principles are not only legal obligations, but moral commitments that safeguard freedom, fairness, and democratic integrity. In the end, the question is simple but profound. Will a nation uphold the idea that no one is above the law, or will it allow individual power to overshadow the principles that hold society together? The answer to that question determines not only the outcome of any specific investigation or legal dispute, but the direction of the entire democratic project. Democracies endure when institutions are strong, when leaders are accountable, and when people understand the true meaning of constitutional responsibility. That is the final message and the final reminder of why these debates matter, and why they will continue to shape political and legal discussions for generations to come.